We'll talk now about acceptance. The second and necessary part of an agreement is acceptance. This means that the offeree agreed to the offer. At common law, the rule was that in order to be an acceptance, the acceptance must be a mirror image of the offer. If a change in any material term was made, therefore did not constitute an acceptance, it was really a new offer, a counteroffer. And the original offeror was free to accept or reject this counteroffer. Here's an example. Suppose that Sarah offers to sell her car to Ahmed for $7,000 and Ahmed replies, "Yes, if you put 4 new tires on it." Example number 2. Sarah offers to sell her car to Ahmed for $7,000 and Ahmed replies, "Yes, if you have the registration." In both examples, Sarah made an offer. They're both promissory, they're both reasonably definite, and they're both communicated. Are they both contracts? No. In the first example, Ahmed changed a material term to the contract, thus making it a counteroffer. Sarah is free to accept the counteroffer or reject it. What is a material term? Material, in this context, means that it would either affect the decision to enter a contract or the price. In the second example, while it looked like Ahmed inserted a new condition, wasn't Sarah's proof of ownership implied in the original offer? Ahmed didn't really add anything. He simply articulated a term that was assumed in the first place. Therefore, in the second example, Ahmed's language is an acceptance. They have a contract. This common law mirror image rule has been modified a bit under modern rules relating to merchant-to-merchant transactions. The UCC, or the Uniform Commercial Code, affects contracts that are merchant-to-merchant. In other words, it's a merchant selling something to another merchant, a business person to another business person. So it will not apply to consumer sales or general retail sales. It affects only the sale of goods, not services. The important distinction here is sales of services are not going to be included, and in general, if it's a combination of both goods and services, it is not included under the UCC. So, for example, if you hire a painter to paint your business, you're buying both paint indirectly and you're also paying for the painter's services. A contract like that would not fall within the terms of the UCC. We're looking for merchant to merchant, sale of goods only. So what does the UCC do to the rule about acceptance? It modifies the mirror image rule for such contracts. The reason for this is because of the increasing use of forms in the purchase of goods. For example, let's suppose that on May 1st, the Valley Electric Company sends a purchase order to Myers Inc. for wire. On the reverse side of the purchase order is a provision that says that in the event of a dispute, the law of the state of Nevada shall apply. On May 4th, Myers sends the wire along with the bill of sale. On the reverse side of the bill of sale is a clause that provides that in the event of a dispute, the law of the state of North Carolina shall apply. On May 12th, Valley sends payment for the wire. Well, is there a contract? Under the mirror image rule, Valley made an offer, Myers made a counteroffer. But now Valley keeps the wire. Is that acceptance? Look, let's get real. Lawyers from both companies wrote this language, and the clerks making and processing the orders aren't even reading this stuff. No one even notices the discrepancy until there's a big mess, after which the lawyers come in and duke it out. This is costly for all of the parties. In an effort to get more practical, some rules created under the UCC mean that in states that adopt the Uniform Commercial Code, which is most states to at least some degree, the traditional common law rules are abandoned in favor of the realities of the modern marketplace. How would the UCC treat the transaction between Valley and Myers? If an offeree, in this case Myers, inserts a new term but otherwise performs the contract, the new term becomes part of the contract if it is not material. but the new term is disregarded if it constitutes a new and material change. In this hypothetical, since Valley had a different term originally, it must have mattered, i.e., it was material. Therefore, Myers accepted the offer, but their new provision did not become part of the offer. Yes, Valley and Myers have a contract. It's kind of idiotic to assert otherwise, since Myers sent the wire and Valley sent the payment, but the jurisdiction will be under the law of the state of Nevada. What I've just described is a bit of an oversimplification, but for our purposes, realize that merchant to merchant, i.e. not consumer transactions, for the sale of goods and services, will use the UCC. The UCC has modified the common law mirror image standard. Now let's talk about a couple of other forms of acceptance. Conduct as acceptance. Contracts are accepted with words normally either oral or written. Occasionally, though, it is otherwise. For example, in our earlier example about auctions, when the ditzy wife was waving at her husband, didn't she just make an offer on the basis of her conduct? The same holds true. Sometimes you can imply the promise through a party's conduct, not their words. For a really mundane example, suppose you go to the gas station and say to the clerk, $40 on 7, meaning you want $40 of gas on pump number 7. Offer. The clerk takes your $40 and punches something into a computer and doesn't say anything. Do you have a contract? Yes. His conduct is taking your money, and that's an acceptance of your offer. Our second example is silence as acceptance. Along the same lines, if it is reasonable for a party to assume that another party's silence indicates agreement, it can operate as such. Normally, however, it does not. What if someone sends you some product in the mail, followed 10 days later by a bill? Did they make an offer when they sent you this stuff? Did you accept it when you didn't send it back? No, not based on this information alone. There's no reason to assume that you agreed to pay for unwanted stuff sent in the mail. Sometimes, however, it is reasonable to assume that someone's conduct is an acceptance. This normally occurs when the other party agrees to the delivery. When you join, for example, the History Book of the Month Club, you agree that they can send you a book every month unless you promptly send them a notification otherwise. Silence is an acceptance to purchase the book, because you said that when you joined the club originally. Consideration. Now, this is really a standalone topic and not part of acceptance, but because of time considerations, we will not be covering the chapter on consideration, so we need a bit of a discussion now. It's a necessary requirement for any contract, and so we're going to discuss it to the degree we need it for our class. Now, is there any difference between the following two agreements? Agreement number 1. Michael agrees to sell his bike to Trong for $30. Agreement number 2. Michael agrees to give his bike to Trong. What if, in either scenario, Michael refuses to follow through with his promise? Is there any difference in the enforceability of the two agreements? Legally, yes. Agreement number 1 is a contract. Agreement number 2 is not. The reason is because contracts including both the offer and the acceptance, must be supported by consideration. Both the offer must have consideration and the acceptance must have consideration. Well, that begs the question, what's consideration? Consideration is defined as a bargain for exchange of legal detriment. This means that someone is either giving something they didn't otherwise have to give or giving up some right they had that based on this agreement. In the first hypothetical, Michael agreed to give up his bike while Trong agreed to give up $30. Both the bike and the money are consideration. So the offer and the acceptance both had consideration, making it a valid agreement. In the second offer, Michael agreed to give something of value, but Trong didn't. This isn't a contract, it's a gift. Michael may be a jerk, in the second example, but it's not a breach of contract because there's no contract. Normally, the issue of consideration does not arise often. After all, most people entering agreements are doing it for something they want out of the transaction. The most common danger area, and by that I mean sort of a hidden topic that you might not easily spot on an exam, is when there's an alteration of an existing contract. Suppose that Glenn agreed to paint your house for $7,500. After beginning the work, he told you that he had misjudged the size of the job and would have to charge you an additional $1,000. You agreed to pay the additional fee. Is this an agreement to pay an additional sum? Does it constitute an enforceable agreement? No, because it's not supported by consideration. Look at the sequence. Original agreement. Glenn agrees to paint the house. You agree to pay $7,500. Modified agreement. Glenn agrees to paint the house. You agree to pay $8,500. See, your modified promise was supported by consideration of an additional $1,000. But Glenn's wasn't. He was already obligated to paint the house. Glenn cannot enforce your promise to pay the additional amount. What's the catch? If the original agreement became subject to glitches, it could not reasonably have been anticipated. An agreement to pay an additional sum really is fresh consideration and thus enforceable. How? Well, suppose, for example, that a fire started on an adjacent piece of property and spread to your house and scorched your house. This caused a portion of the freshly painted house to be damaged. If Glenn agrees to paint all of the damaged area for $1,000, this modified agreement is enforceable. After all, Glenn couldn't reasonably have anticipated this and built it into his original price of the cost of repainting. What ends up in sticky litigation is the question of whether the party should have anticipated the particular events. And this is what makes work for lawyers. So, a business person's advice, if you want to make sure that you're paid for everything you agree on, try to anticipate any future events and work them into the price structure. And if you need to modify the contract, change something else. For example, in the original agreement with Glenn, if Glenn had agreed to an earlier finish date, the modified agreement would have been enforceable. He incurred a responsibility or a legal detriment not present in the original agreement. Again, consideration is a complex problem, topic that we don't have time to cover fully, but I do want you to be aware that gifts are not contracts, they are not legally enforceable, and to use particular caution when there are contract modifications. Make sure any modifications are supported by consideration on both sides, otherwise they're generally not enforceable. And that concludes our discussion.